Hello, everyone. This is Dr. Stringer. I am back here talking to you all this week about searches for evidence. This module is also going to cover confessions as well. However, this video right now is just going to talk about searches for evidence. One of the fun things that I like to do when I talk about searches for evidence with students is to talk about Jay-Z's music video or song, so to speak, with the lyrics of his song is called 99 Problems. For those of you who haven't heard it, I'll post a YouTube link on there so y'all can listen to it. But mainly pay attention to the parts where he's talking about the glove compartment being locked and he's pulled over by the police and things like that. One thing to note too that I often like to tell students is he likes to say I got 99 problems, but a B, uses the B word, aren't one or isn't one or something like that. And I know that this sounds very misogynistic and stuff. However, he's actually been interviewed after this, and if you think about it, it makes sense given the context of the lyrics. He's not talking about a woman. He's talking about the canine dog that they were bringing to search his vehicle, and they had kept him there for a while. And then he had to be let go because they can only hold you for so long before the canine gets there. And so as he's driving away, the canine is coming the other way. And so he's saying, I've got 99 problems, but that, female dog isn't one. In case you don't know, the B word isn't actually started as a name for a female dog. Anyway, but we'll talk about that a little bit as we progress through this content. I think it's an interesting thing to apply criminal procedure to his lyrics. So anyway, so we're going to talk about, consent searches, inventory searches, a lot of different stuff. These are our main, learning objectives. You probably see these in your D2L as well. So when I teach this face-to-face, I usually present students with this hypothetical situation, and then we talk about it in class. Obviously, given that you all aren't here with me, we don't have time to do that, but we might look at that later. Anyway. Searches and crime control. Well, for those of you that don't know, searches are a rather important part of crime control, and they're important for officer safety and other things like that too, as well as safety of the community. And crime control really couldn't survive without searches. You might want to remember that the Fourth Amendment is what controls searches and the need for searches and the requirement that officers have probable cause for searches. And searches can be done both with and without a warrant, which is a common misconception that people think that officers have to have a warrant. That is not necessarily the case, and there are a whole bunch of exceptions to that rule. The only really time that you really have to have a warrant is if you're going to search someone's house most of the time. And again, there's a lot more going into that. So when you're looking at a search, there's three main questions that you have to ask. When you're determining was it reasonable, was it in violation of the Constitution. First, was it a search? There's something known as the plain view doctrine, which says that if something is in plain view of the police, then they haven't conducted a search. And this has actually been applied to plain smell and things like that, plain touch. If the police pull you over and you roll down the window and a big cloud of marijuana smoke pours out the window, or a strong odor of alcohol, that isn't a search because the officer is standing there and he just smells this while he's there. And he has not conducted a search, so then you couldn't say that that was reasonable or not. And so then if it was a search, then you would say, well, was it a reasonable search? And we'll talk about what a reasonable search is, what an unreasonable search is in various contexts. If it was unreasonable, then should the evidence be excluded? There is something called the exclusionary rule, which we would go through a whole lot of detail about again if this was criminal procedure, but it's not. So we'll kind of mention that, sometimes when a search is conducted illegally, evidence can be excluded, although it's not always excluded. It doesn't have to be. But we would go into a big diatribe if we started talking about that. So anyway, searches versus non-searches. And these are just a few examples of, searches versus non-searches, right? So if you look at, let's see if I can get my pointer to work here, eavesdropping on a phone conversation, that's a search, right? Climbing a backyard fence, opening a briefcase, Overhearing a conversation on the street? That's not a search. Observing a backyard from the window of an airplane? Nope, still not a search. Standing on the street and looking through a window? Nope. If you're in your car and the police can see through your windows of your car and they see you with a gun shooting someone in the passenger seat, they're not conducting a search, but they're observing you, shooting someone. So they don't need to conduct a search. Like I said, there is something known as the plain view doctrine. And this means that the police, if they see something in plain view, it is not a search. And I always give the example of Tony Montana with his, big pile, his desk there with all of the cocaine piled on it. And so, if you happen to be in his office or something, and you saw this there and you're legally in his office, then that would be in plain view, right? Now, obviously, it's not in plain view if the officer's out on the streets, right? So, that would be something that would be in plain view. The officer has to lawfully be there, though. They can't kick your door in and then run up to Tony Montana's office and then say, oh, well, I see it in plain view now. No, but you weren't supposed to have kicked the door in and be in there anyway. I think another example would be like your car, right? Tons of people get pulled over and then they have a blunt or a joint or something in the ashtray of the car back when cars had ashtrays, or maybe they have an open container, or, it's amazing how when people get stoned, they forget to hide their drug paraphernalia. You might see a glass pipe sitting in the console or cup holder or something like that. That's in plain view. Another reason why, if it's dark outside and the police ask you to give them their license and registration, and most people keep their registration for their vehicle in the glove compartment, right? Well, in order to get to their registration, they have to open the glove box. And the police are always so friendly and nice and helpful by shining their flashlight into your glove box to help you to find it. It's not truly altruistic. They're also shining the light in there to see if they see anything in the glove box, because people will also put drugs and guns and other things that they're not supposed to have in the glove box, thinking it's out of sight, but then they forget that their car registration is in there as well. So, just saying, if you ever have anything that you're not supposed to have in your vehicle, you might not want to put it in the glove box with your car registration, because if you get stopped, they're going to ask you for it, and then you're going to have to open the glove box, and whatever they see in there will be considered to be in plain view. So that has happened plenty of times as well. And you'll see I've got links here to some videos that I tend to show in class sometimes, but we're not going to watch those in the interest of time, and this being an online class, and I can't actually show you all the video on here. You could watch it, but you won't be able to see the audio, or hear the audio, sorry. Anyway, so like I said, there are many exceptions to the warrant requirement. Officers do not have to get a warrant, and there are many exceptions to that, and in fact, most searches are done without warrants. So we'll talk about many of these exceptions as we move forward with this little short video lecture. So there are three main requirements when you're getting a warrant. One is the particularity requirement. You must say who the person is or the place that you want to search. So I want to search 1000 Chastain Road or something like that, right? Or I want to go and arrest Richard Stringer, and this is his name. Like I said in a lecture, I think it was last week, they also can put the DNA strand code in the warrant. If they don't know who the person is, but they have the DNA strand, they can put that in the warrant. That satisfies the particularity requirement. And then when they find out whose DNA that is, then they attach a name to it. So that's another thing to think about. You have to have particularity. When you're doing a search, you also have to put what you're looking for in there. And so this is an interesting thing, and it's come up in some cases as, police say that they're going to look for assault weapons or something like that. Well, if you're going to look for an assault weapon, then the police would not be justified in searching the drawers of my desk, because an assault weapon is much larger and would not fit in the, in the drawer of my desk. Or if you're going to look for a missing person, or you're going to arrest a wanted person in a home, you would not then have justification for going into my desk drawers because that person could not possibly be hiding in there, right? You would, you could open a closet door, things like that, to look for a person. And so, a lot of times when officers get warrants, what they'll do is if they're looking for assault weapons, they'll put assault weapons and evidence of assault weapons, like assault weapon bullets, like maybe you put 5.56 NATO ammunition or .223 ammunition or something like that, because a bullet could be anywhere in here, right? It could be in a desk drawer, it could be in someone's pocket, and so that then opens up the search parameters to a broader area where they can look for stuff. And sometimes they'll go and search a house or a car or something with a warrant, looking for guns, and then they might find drugs. And you might ask, well, are they allowed to seize the drugs? Absolutely, because of the plain view doctrine. They're legally in this home serving a search warrant. It just so happens that they're looking for guns. They didn't know you had 10 pounds of cocaine, but then they found that cocaine while they were there, and they're absolutely going to search for that cocaine if they find it and keep it and seize it, and then probably arrest whoever's there. So I'm not going to go into a huge diatribe about this. I feel like I've covered the first one fairly well. But anyway, the second criteria is probable cause. Remember we talked about the different burdens of proof, with probable cause being an important one. Probable cause is what you need to get a search warrant. It is also what you need in order to conduct a warrantless search, with the exception of the Terry versus Ohio, the stop and frisk situations, which are not really considered searches. So that's why they use a reasonable suspicion. Anyway, and so probable cause is that something is more likely to have occurred than not. And then finally, the knock and announce rule. Now, the knock and announce is typically, that police officers are required when they're entering a home to knock on the door and then announce themselves as police, and give you a reasonable amount of time to open the door before they kick it in. The Supreme Court has never said what a reasonable amount of time is, and for those of you that don't know, typically what will happen is bang, 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 police, and then kick the door in or ram the door. So that I don't know that I would consider that to be a reasonable amount of time. You want to give them the amount of time to get off the couch, make it to the door, and open it, but the police don't want, for their own safety and for preservation of evidence, they don't like to give people a lot of time, because if they're in there, they know the police are coming for any amount of time. It gives them more time to find a weapon. It also gives people more time to destroy evidence, right? Start flushing things down the toilet and things like that, which is another reason why they don't wait very long between that happening. There's also what is known as a no-knock warrant that you can have issued as well. And that's an exception to the knock and announce rule. I don't know that it makes a whole lot of difference because they don't really wait very long before they announce. And if you don't announce, I think it could, there's been cases where people didn't know it was the police breaking into the home and they shot back at them and things. And one person actually murdered a police officer back up north, and he got manslaughter because his attorney was able to show that, they didn't, or now he didn't know that it was the police, and the house had been broken into previously, and so he didn't, know that he was shooting a police officer. But anyway, if you can show the judge probable cause that for officer safety or preservation of evidence that you should not have to knock and announce, then they can issue you a no-knock warrant, is what it's called, where you don't have to knock and announce. It's essentially the same thing, you just don't knock and announce. Anyway. Like I said, I forgot to mention prevent suspects from escaping. These are the major exceptions to that. So prevent violence, prevent people from getting weapons and then trying to fight back at the police when they enter the home, to prevent the destruction of evidence, and prevent suspects from escaping. If you're going to search a home for a person who's wanted, if they hear the police are at the door, they might be tempted to run out the back. Although, regardless of whether you knock or not, if you're serving a warrant for a wanted person, you're going to have all the exits to the home covered. So if they do run out the back, you'll have someone back there to apprehend them. assuming you have your department is well equipped and has enough people and good training enough to know that you need to do that. So I don't think that one's a very big one, which is probably why I didn't think to mention it before. Anyway, so searches without warrants. There are a lot of exceptions to the warrant requirement, and they're very broadly interpreted this. So don't think that the police have to have a warrant anytime they're searching something, because chances are they probably don't. So there's 5 major exceptions to this, and we'll talk about these. Searches incident to arrest, consent searches, vehicle searches, container searches, and exigent circumstances or emergency searches. And I won't go into all those right now. It's just a brief overview of them all because we'll go into them in more details as we're moving forward. So here's, when I teach this face-to-face, I usually play the video of Jay-Z, and this is actually a photo of Jay-Z from the video. For those of you that haven't seen the video, I'd say go and watch it because you can actually see the scene here. Which, before I started doing this, I heard the song before, but I'd never watched the music video, which is interesting because I'm from the age where MTV actually played music videos when I was younger, but I just didn't watch that much TV. But anyway, I think it's interesting, and hopefully it'll help you all to retain some of this, and maybe you'll find it more interesting than just a boring lecture on criminal procedure. I know students always have in the past, and so they really enjoyed it. So I hope you did too. So when they get to the stop, so here's just some of the words from it. And so, son, do you know what I'm stopping you for? This is after he's pulled over. Because I'm young and I'm black and my hat's real low. And so this is the New Jersey drug courier profile. During that time, they actually had a drug courier profile, which is actually this pretext for the stop. And actually, there's an interesting case law behind this, and I don't know how I feel about it. But in Wren versus U.S., they actually said that racial profiling is not grounds for suppression of evidence if there is probable cause for the stop. So that's just a little side note there. So, am I under arrest, or should I guess some more? So, arrests can be made even for a minor traffic violation. And then search incident to arrest is constitutional. If you arrest someone, the police can search them. They're going to be taking them, putting them in the backseat of their car, taking them to the jail. And if you're arrested, once you get to the jail, then the jail officers are going to search you again. Where you'll probably be strip searched and other things because you'll be going into the jail facility. There's a lot of case law over search incident to arrest, and it's not really that much of a controversial issue because no one really argues that there has been able to come up with any sort of successful argument that we shouldn't allow the police to search people whom they arrest. What a lot of people don't know is that you can actually arrest someone even for a minor traffic violation, and it's constitutional. Now, there might be state laws against it and things like that, but that's different from the Constitution, obviously. I'm sure you all have learned about the hierarchy of law from courts classes, so I won't go into that. Anyway, so searches incident to arrest serve 3 main functions, right? To protect the officers for officer safety, to prevent escape, because, I forgot, I haven't told this story, but last year or the year before, I was at the Pigs and Peaches Festival in Kennesaw, and the police explorers from Kennesaw PD were raising money by handcuffing people for donations. And so I went and played along with them and let them handcuff me. And they didn't know this, but I have a handcuff key on my key ring. And so he wasn't paying attention, and I got into my side pocket, got the handcuff key, and then undid the handcuffs, and I freed myself. And so he's, whoa, oh my God, how did you do that? And I said, it's magic and whatever. But then I explained it to him. And I said, yeah, you have to be very careful about searching people when you put them in handcuffs. And there's been many police officers who have actually been shot over the years because they put a suspect in handcuffs, they don't search them well, and then that suspect has a gun or something in their pocket, and they pull it out and shoot the police officer. So you have to be careful. The handcuffs are not really all that secure and safe unless you search the person. They kind of tend to lead officers into a false sense of security because they think, oh, well, they're in handcuffs, what are they going to do? If they've got a gun in their pocket and they can get to it, they can shoot you with it. If they've got a handcuff key like I do, they can get the handcuffs off, and then handcuffs are virtually, useless. And the handcuffs, they can actually hit you with those things are metal, they can hurt. Anyway, the second being to prevent escape, right? Like once I got the handcuffs off, I could have gone either assaulted the officers or ran the other way, something like that. The other reason is to preserve evidence. And you'll see also that police officers, after they search someone and put them in the back of the car, they often search the back of the car after they get them out because people will tend to lose things out of their pockets and various other places in the back of the police car that they don't want to be found. So that's an important thing, too, to preserve the evidence. The Robinson Rule, under the Robinson-Ratline Rule, officers are always permitted to search anyone they take into custody. There is no automatic search incident to citation rule, though. So if they write you a ticket, they can't search you for that. So it's important to remember that. And this is because of the danger of taking people into custody, yada, yada, yada. So when you search someone incident to arrest, you can search not only their person, but as what is known as their grabbable area. Oftentimes we'll call it a wingspan search because you can essentially search as far as that person's hands can reach to see if they have any weapons there. And this is for officer safety, obviously, to see what they have access to. If they're in a car and you search the person and then put them back in the car, they could still have access to a gun that's underneath the seat or something like that. This was being abused quite a lot for some time because the police were saying, oh, well, I'm searching his grabbable area, and so they would search the car, but this is after they'd already handcuffed the person and put them in the back of the police car. And so in Arizona versus Gant, they actually overruled this and said, no. So for those of you that don't know, you don't have to know all the case law. It's not that important. But just for those of you that are interested, Schindler versus California is the case where they actually created this search incident to arrest law. And so for a long time, police were, arresting people, putting them in the back of the police car, and then going and searching the car. And then it wasn't until Arizona versus Gant, and I forget the year that came out. It's probably been 10 years ago or something like that. It might be a little bit longer because I'm getting old. But they said, no, you've been misinterpreting what we said. We didn't say that you could search the grabbable area after they're already not in the grabbable area. That defeats the purpose. We're saying if you're going to search someone and put them into their back where they were, like say they're sitting on the couch, you can search that area too to make sure that there's no guns there. And so that it's changed a little bit since then because now police are not doing that anymore. So it's one of those little loopholes that they found that I always think is interesting. So one of the things that we talk about too in class is, Gant actually didn't make a whole lot of difference, especially with vehicle stops, because of the next exception that we're going to talk about, which is going to be inventory searches. And so inventory searches essentially mean that suppose they've stopped a car and they're going to arrest the driver for a DUI. Well, they pat down this driver, handcuff him, put him in the back of the police car, and now they're going to tow this person's vehicle. They're not going to leave it on the side of the road. They're going to have it towed. Well, under the inventory search laws, then the police are allowed to inventory that vehicle in any of the containers, anything in there, to see what's in there, make sure there's no bombs, hand grenades, things like that, in the car before they tow it. Now, inventory search is essentially the same thing as a regular search, right? And so, your car is going to be searched if you're arrested under the inventory search guideline rather than just the search incident to arrest, which it almost makes the whole Arizona versus Gant decision kind of moot, right? But anyway, I don't want to get too much into all of this. Like I said, this is a criminal procedure. Well, you were doing 55 and a 54. It's an arbitrary and pretextual motive, but it is sufficient to make a stop. The police can stop you from going 1 mile an hour over the speed limit. Now, they don't usually do that, but they can. And so, you think about it, the police might see a suspicious vehicle and they want to stop them. Uh, so they'll say, well, we're going to wait for them to make a minor traffic infraction, something like that, which almost everyone inevitably does, and then they stop them for that, and they have said that that is fine. So, like I said, Wren versus U.S. said that this is, search incident to pretext. You can have some sort of hunch. So maybe it's 2 o'clock in the morning. You see some people in a high drug area stop, and they're leaving the drug house or something like that. So you think, well, maybe I want to stop these people, see if they have any drugs on them or whatever. But you can't necessarily do it just on this hunch, but you can follow them and then stop them for speeding or whatever down the road. And the Supreme Court said that that's perfectly constitutional and legal. Um, so the next part of the lyrics, they say license and registration, step out of the car. Are you carrying a weapon on you? I know a lot of you are. So as we said before, last class, officers can pat down suspects for weapons under the Terry versus Ohio case. And like I said last class too, I need a reasonable suspicion, not probable cause, which is defined as specific articulable facts that give risk or give rise to that suspicion. Michigan versus Long extends the frisk to the car for readily available weapons as well. So anyway, here's another interesting video that I like to show my students too in class. I have a lot of these little short videos. I might put this one on D2L too because it's really interesting. And so here Jay-Z says, I ain't stepping out of, all my papers legit. And so you cannot do that. That is actually illegal. If the police ask you to step out of your vehicle, then you need to comply and do that. And what happens here with this Henry County video is that this woman is being stopped for some very petty offense. I think her brake light is out. And so the officer is just like, can you give me your license and registration? She refuses to give him the license and registration. It only goes back and forth for a little while. Eventually, they say, well, look, all right, then we need you to step out of the vehicle. That she won't step out of the vehicle. She won't give him the license and registration. She's been legally stopped for a broken tail light. All they want to do is write her a ticket and then let her go on her day. So they talked to her for a while, and they're like, hey, look, if you don't, roll down your window and give us the license and registration, we're going to have to break your window. She keeps saying all this stuff. She keeps citing this case, which is from California, which actually doesn't apply at all in Georgia. Which is interesting in and of itself. Long story short, they end up breaking the window. Then they bring her out of the vehicle. She gets a ticket for, I think, the brake light, and then an obstructing justice or something like that charge. And all because of this silly broken tail light thing, which is interesting. So anyway, I might post that later if you want to, or if I don't and you're interested, just send me an email and I'll send you the link. If it's still on YouTube. Anyway, when you want to get into a car, how often do you use weapons, Terry, as a justification? And this is from this article, which I posted the article that actually analyzes all of those lyrics from Terry versus Ohio, and you can all read that essentially for yourself if you want. But essentially, they really use this a lot to be able to search vehicles without probable cause, just to see if there's weapons in there. Because if you're looking for weapons, you can pat someone down if they have weapons. Well, when you're patting them down, you might notice that you feel what you know to be a crack pipe in their pocket. And then if you know that that's a crack pipe, then you can retrieve that, and then of course you've gotten them for that. So, this is used a lot in policing, and whether it's ethical is an interesting debate to have in class, which we often do in my campus class. But anyway, we could go on and on about a lot of this criminal procedure stuff, and we only have 1 week to talk about this, and so I'm going to try not to go on for too long. But anyway, as I digress. Well, my glove compartment is locked, and so is the trunk in the back, and I know my rights, and you're going to need a warrant for that. This is a very big urban myth. The police do not have to have a warrant to search your trunk or to search your glove compartment, even if it is locked. So if you don't take anything away from this class, know this. Now, if they were just searching your immediate area for weapons and they don't have probable cause, then yeah, they could just search this area that's within your immediate reach, right? But if they have probable cause to search your vehicle, they do not need to get a warrant. So maybe they smelled marijuana in the vehicle or something like that. They can search your trunk, they can search your glove compartment. It doesn't matter. They can search those areas if they have probable cause. And in no circumstance do they need to have a warrant to search a vehicle. Vehicles are a big exception to that because of their mobility and everything like that, which we're not going to go into because this isn't a criminal procedure. So then they have some more dialogue. Aren't you sharp as a tack, some kind of lawyer or something, or I ain't past the bar, but I know a little bit, all that good stuff. And so, do you mind if I look around the car a little bit? Police officers are trained to ask for consent, and most people give it. And this is something that we talk about in class a lot too. About 90% of people who are asked if they can if the police can search their car, give it, even if they know that they have illegal things in the car, which just amazes me. But people do it. If you have a bunch of stuff in your car that you're not supposed to have, and the police say, "Do you mind if I search your car?" Say no. I know I'm telling you this, and actually I'm not telling you this. Never mind. But it just boggles me because you have a right to say no. I know no one in this class would have anything illegal in their car anyway, so it doesn't matter. But if you think about that, people tell the police, yes, you can search my car, and then once you've given consent to search your car, your lawyer, regardless of how good he is not going to be able to do very much. Because now your Fourth Amendment rights are out the window. You've waived your rights and said, no, I am okay with you searching my car. And that's the end of the story. And so that's what's known as a consent search, which is another one of these exceptions to the warrant requirement. So if you give them consent, then they can search the car, the house, whatever you give consent to. You say, they ask you to search your clothing or your person, and you give consent, and you've given consent. So that's pretty straightforward. I won't dwell on that too much because, consent is consent, right? I think I already talked about the glove compartment and the rights and warrant. Locking your trunk will not prevent the whole car, everything in the car. Now, that's interesting, too. If they have probable cause to search the car and maybe someone's purse is in the car or something like that, they can search that car and the purse. They can search the passengers, all those things like that. And so I always say the line at the end here shouldn't be, I know my rights, so you're going to need a warrant for that. I say, I know my rights, so you'll need some PC for that. And PC means probable cause. If they have probable cause, they can search your car. Without probable cause, they can't. But with probable cause, it doesn't matter what's locked, what's unlocked, all that good stuff. So that will not help the situation. And here, reduced expectation of privacy. Interestingly, mobile homes actually fall under the vehicle search exception. So remember I said, usually you need a warrant to search a house. Well, a mobile home is a vehicle, right? It has wheels and an engine. So they don't need a warrant to search a mobile home either. The passengers can be searched even without probable cause due to the reduced expectation of privacy. And this is said, and I say this in Wyoming, so this isn't a Supreme Court case. But anyway, you can pat down passengers, like I said, for weapons and things like that, even if you don't have probable cause. And so here we get to the end. We'll see how smart you are when the canines come. And if you don't consent to a search, and the police really want to, see if you have any substances in your vehicle, what they can do is have a dog walk around the exterior of your car and see if the dog alerts, if the dog smells anything. And Illinois versus Cabales has said that that is not a search when the dog just walks around the car. They've also said that if the dog alerts, now the dog alerts most of the time, they train the dog to alert is that they sit right down in front and look at whatever the substance is, right? And so that's how they alert most of the time. So that's what will happen. One thing to think about, though, is police resources. You know, if you're in Marietta or in Atlanta or something like that, a big city, chances are they're going to have, a canine or maybe multiple canines working on every shift. But if you're in a smaller, more rural area, they might not have a canine. And so if there's no canine on that working that shift, then they're not going to be able to walk a dog around there, right? Um, in Jay-Z's situation, they had a canine on that shift, but the canine was busy with another call, so there was a little bit of a delay before the canine could get there. They weren't immediately available. And so under U.S. versus Jones in 2001, they said that you cannot detain someone longer than necessary for the dog to arrive. You can keep them there as long as it's reasonable. So if you're pulled over for going 55 and a 54, they can keep you there for 20 minutes or so, long enough to write you a ticket and then for you to be on your way. They can't keep you there for 4 hours waiting on some canine that could be there eventually or not. And so that's what happened in Jay-Z's case. He says it's a real story, which is interesting to me. That's how Jay-Z ended up getting away from that. And apparently he said his trunk was raw or something like that, which meant he had a bunch of drugs in the trunk too. So I'm sure he's happy that the canine was just a little bit too late. So that's an interesting thing to think about. Canine dogs can walk around your car. If you don't have anything in there, then it's not such a big deal. So then, the final exception to the warrant requirement is what is known as emergency or exigent circumstances. Exigent is just a big word for emergency. Well, actually, emergency is a longer word, but exigent sounds like a bigger word. Anyway, so there are some situations where they make it impractical for officers to get warrants before searching something. And so this might be officer safety, which is the justification for frisks and pat downs of people, right? And if you think about it, just patting someone down, their waist and maybe their pockets, just to make sure that they don't have any guns on them or big knives that they're going to stab you with, it's not really that much of an infringement into someone's privacy, right? And so they let that slide with just reasonable suspicion. And there's another example, that evidence might be destroyed, fleeing felons might escape, that people in the community are in immediate danger. So, for example, if you're at the airport and you see a weird backpack that's just sitting all by itself, they can go into that backpack. They'll probably send a bomb squad to go check it and all that kind of stuff. But they're not going to wait for a warrant to come. They're not going to go all the way down to the courthouse, go get a warrant, and come back and go through all that process. If there's potentially a bomb in this briefcase, book bag, whatever it is, they're going to go get the bomb squad and make sure that's not it's not a bomb in the interest of public safety. And that's another reason why they tell you not to leave your backpacks or unattended luggage at the airport, because when they see that sort of stuff, they get a little nervous. So anyway, destruction of evidence, probable cause to believe that, the evidence might be destroyed. Hot pursuit is another interesting one. So, for example, if the police are chasing someone and that person runs into a house, the police don't have to wait for a warrant to go into that house to chase that person that they're chasing, that is running from them. They can follow that person through there. And one thing that I like talking about with my students is, and we talk about in class, is, okay, maybe you're chasing someone for, I don't know, you suspect that they're drunk driving or possession of marijuana or something petty, right? But they ran from you, so you're chasing them. And then This person happens to run through Tony Montana's office while he's sitting there with a mountain of cocaine. Well, most police officers, if they're running and chasing someone for a small DUI offense or something like that, and then all of a sudden this person runs into Tony Montana's house, and he's got a desk with a mountain of cocaine, all of a sudden they might be less interested in that person that they were chasing for the DUI, and they might stop and ask Tony Montana what he's up to. For those of you that don't know, Tony Montana is from the movie Scarface. I know it's probably before a little of your time, but most of the guys have probably heard of this movie or maybe even seen it. It's a really interesting movie. It's Al Pacino, and anyway, I won't digress too much on that. But they can do that if you're in a hot pursuit, and all of a sudden you see a criminal who looks like you might be more interested in them. Or maybe, you run through this house chasing someone and there's a man beating his wife or, molesting some child or something like that in the house here. Then you stop and say, hey, I'm going to get this guy. We'll worry about the DUI person later. You can focus more on the felony offense than the misdemeanor. Danger to the community is another big one. Like I said, if there's a backpack at the airport that's unattended or something like that. And so usually I'll discuss, whether the search of Jay-Z's car was illegal. And these are just some things to think about. I thought about having you guys do a discussion post about this week. So we'll see whether that works out that way or not. Or I think we might actually do something on interrogations and confessions, since you've already heard me talk about this. But anyway, so that's all I have for today. All the way down here. Okay. All right. Well, with that, I will bid you all adieu and tell you all to have a good day, and I'll talk to you next.